I have an update in the Bianchi, Maryland assault weapon ban case, which is currently up for Supreme Court review. The case sets the stage for a huge case that can in fact strike down rifle bans nationwide, so we need to talk about what is happening in this case. Now, real quick before we jump into this video, if you think that these types of rifle bans are clearly a violation of the Second Amendment, go ahead and hit that like button and subscribe. Also, I want to thank one of the main supporters of this channel, which is 1st Phorm. 1st Phorm is an amazing company. I stand behind them. I've used their supplements when I've been going on a health journey, used it before they were ever even a sponsor, and now they're a sponsor of the channel, which is absolutely amazing because a lot of the guys over there watch this channel. They support the Second Amendment. They're pro-freedom. So if you guys want to support a company that's absolutely awesome, believes in freedom, check out 1st Phorm, and you can check them out using the link down below. As I mentioned in the intro, we're going to be talking about a critical rifle ban case that is now up for Supreme Court review. You may recall that the Second Amendment Foundation recently filed for a writ of cert before judgment in a case called Bianchi versus Bruen, and this deals with Maryland's ban on so-called assault weapons. This now sets the stage for a critical Supreme Court review of a state rifle ban that can have broad-reaching implications and is very significant for a lot of states, not just Maryland, but other states, including states like California, New York, and New Jersey. And this case and the review comes on the heels of the 4th Circuit en banc panel recently playing a ton of games in this Bianchi case, taking the case out of the hands of the lower court and essentially taking it out of review from the 3-judge panel after the case sat for 13 months after oral arguments. In response to that, the plaintiffs here, Second Amendment Foundation, Firearms Policy Coalition, and all the other plaintiffs have filed for a writ of cert before judgment to the United States Supreme Court, and they're asking for the Supreme Court to step in immediately and strike down this type of state rifle ban. The state of Maryland has responded to this effort by arguing now that not only is this case too premature for Supreme Court review, but also they are arguing that this case and this kind of setup here in the state where they're banning rifles is not impacted at all by the Bruen decision that was recently issued by the Supreme Court. And also, it really isn't even controlled by Heller. Heller does impact this case, but they believe that Heller actually protects this type of conduct. But funny enough, Second Amendment Foundation has now played a reverse Uno card on the state of Maryland and used their arguments against them and is using it to actually support Supreme Court review. They agree that Bruen did not actually alter Heller's decision, and because of that, these types of rifle bans have been an issue that have been sitting in clear conflict with the Second Amendment and Heller since 2008. So the argument that this case is too premature for Supreme Court review is in fact false, even just following what the state of Maryland said. States have continued to defy what the Supreme Court said since 2008, and now it's pretty much time for the Supreme Court to finally correct that issue and step in and strike down these bans. Now, for those not aware, the state of Maryland identifies certain rifles as so-called assault weapons. Maryland bans the sale, transfer, and possession of semi-automatic centerfire rifles with detachable magazines and 2 offending features, and those features could include things like folding stocks, flash suppressors, grenade launchers, flare launchers, and a bunch of other characteristics. The ban was challenged in a Maryland district court, a federal court, and in the complaint, the plaintiffs here had to concede that their Second Amendment claims were in fact foreclosed at that level based on a prior 4th Circuit decision in a different case called Colby. A prior case, Colby, challenged Maryland's assault weapons ban prior, and in that Colby case, an en banc panel in the 4th Circuit upheld Maryland's rifle ban. They found that it was in fact constitutional, didn't violate the Second Amendment, and they used something known as the military use test. Essentially there, the 4th Circuit en banc panel in the Colby case said that these types of rifles are outside the protection of the Second Amendment because they are useful in military service. They tried to say that things like AR-15s and AKs, which are semi-automatic rifles, are one and the same and almost identical to M16s, and therefore they could be banned because in some way they are useful for military service, even though military service, in the military at large, don't actually use these types of semi-automatic, rifles like AR-15s. But here, the 4th Circuit en banc panel in Colby said that they were similar enough to actually justify a ban. This case, Bianchi conceded that Colby is the controlling precedent, but that it's simply incorrect and they used the wrong type of analysis, and that case should be reversed. The district court in this case, Bianchi, ultimately dismissed the complaint for a failure to state a claim, and then that dismissal was upheld by the 4th Circuit when it went on appeal. Now, originally this case went up to the Supreme Court back in 2022, and they were seeking review of this issue. The Supreme Court ultimately ruled in a landmark case, again, we've mentioned it, Bruen, and they found, among other things, that the correct way to review Second Amendment cases is to look at the text as informed by relevant history and tradition of the Second Amendment, and the relevant history is that dating back to 1791. Now, this is all outside of what Heller also says, because Heller says very clearly that if an item is in common use for lawful purposes, well, then there cannot be a categorical ban like what is going on in Maryland. Now, after issuing that ruling, the Supreme Court issued a GVR, which is a grant, vacate, and remand of this Bianchi case. They send the case back down to the Fourth Circuit for them to reevaluate and reconsider this case in light of Bruen. The case was then opened back up in the Fourth Circuit, and a 3-judge panel heard oral arguments on this case back in 2022 in December. Then this case sat pretty much dormant and silent for 13 months. Then out of nowhere, the Fourth Circuit en banc panel took control of this case, took it out of the hands of that 3-judge panel after 13 months of it sitting silent. But instead of waiting for the Fourth Circuit en banc panel to review this case and to decide this case, the awesome team over at SAF has now submitted for a petition for a writ of cert before judgment. This is a completely different mechanism for early Supreme Court review, and in my opinion, I appreciate that SAF is trying to get the Supreme Court to step in early. Essentially, this is a way to bypass hearings and rulings in lower courts and instead go directly to the Supreme Court for an actual ruling on the merits before, actually waiting for the lower court to decide on the case. But in the state of Maryland's new response brief, they argue that not only do they believe that Bruen does not change the outcome of the Maryland ban, but also that this issue is too premature for Supreme Court intervention. In their brief, the state of Maryland argues that although Bruen rejected the tiers of scrutiny framework that many courts of appeals have applied, the court left intact its pronouncement in Heller that M16 rifles and the like are weapons that may be banned. Maryland, in their brief, tries to use the unfortunate dicta language that's in Heller about M16s, and they believe that this language means that their outright ban of semi-automatic rifles is in fact constitutional. They argue that the subsequent Bruen decision and the remand of the Supreme Court in this case for reconsideration in light of Bruen essentially means very little. They say that this remand and Bruen really doesn't impact this case at all. Maryland argues that the remand in light of Bruen is isolated only to the fact that there was tier-based scrutiny that was used prior in this case, and the reconsideration is really in regards to tier-based scrutiny being struck down. They also go on to argue that the Supreme Court should not intervene in this case at this time because this case is still being decided on the merits by the Fourth Circuit en banc panel. This issue is still percolating, in their opinion, in other lower courts, and so this issue still needs to develop more at the lower court level, not only in the Fourth Circuit, but other circuits, to see really how Bruen applies to this type of issue. Now, in the recent brief to the Supreme Court's Second Amendment Foundation and the plaintiffs, just used these statements by the state of Maryland against them to actually support Supreme Court review. They argue that petitioners agree with the state of Maryland that this court's decision in Bruen left Heller undisturbed, but that fact undermines Maryland's position. With respect to timing, this court decided Heller in 2008, which refutes the argument that it is premature to address the question whether state bans on common semi-automatic rifles are consistent with the Second Amendment. With respect to the merits, a straightforward application of Heller demonstrates that Maryland's ban is unconstitutional. As Heller holds and Bruen repeatedly confirms, law-abiding citizens have an absolute right to possess firearms that are in common use for lawful purposes, and there can be no question that the rifles Maryland bans are in common use. Indeed, they include the most popular rifles in history of the nation. To be sure, granting certiorari before judgment is not typical, but neither is sua sponte seizure of this case by the en banc panel in the Fourth Circuit 13 months after argument, nor is the continued incapacity of lower courts to grasp the plain teaching of Heller in this context. This court should grant certiorari to make more explicit what should have been apparent with the issuance of Heller in 2008, that the government simply lacks the authority to ban commonly possessed arms. What the plaintiffs skillfully did here is they agree with Maryland that the 2008 Heller decision controls this case and should primarily be used in this case. And because of that, the case here is more ripe actually for Supreme Court review, despite what the state of Maryland says. The fact that lower courts still are incorrectly applying Heller 16 years after that decision means that the Supreme Court needs to step in finally and cure this issue. So things are getting very interesting with the Supreme Court right now with the rifle bans. There's a ton of them coming out of the state of Illinois, seeking Supreme Court review from the state of Illinois, but those are interlocutory cases. They're reviews of preliminary injunctions. However, this case here is a merits case. It's a case that went to the Supreme Court before back in 2022, was GVR'd by the Supreme Court in light of Bruen, and now it's finally, up in front of the Supreme Court again. So again, very interesting case. As things develop, I will let you guys know. Also, if you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.